Hello everyone, and welcome back to the channel. Today, we are diving into a crucial topic for your AS and A-level law exams, trespass to land. Whether you're looking to master the core elements for a problem question, or looking for the key case law to brilliant asset and essay, this video will break down everything you need to know. We'll cover the legal definitions, the critical case authorities like Entick v. Carrington and Baisley v. Clarkson, and the essential defenses that examiners love to test. Grab your notebooks, make sure you're ready to take down some key legal principles, and let's get right into it. Now, let's explore the historical background and the core characteristics of trespass to land. The tort of trespass to land developed in 13th century English common law. Its original purpose was twofold. First, to protect an individual's right to the exclusive possession of their property, and second, to prevent localized land disputes from escalating into physical violence. To achieve this, the common law relied on a specific legal mechanism known as a writ, specifically, trespass quare clausum fregit, which translates to breaking the close. In a legal context, the close refers to an invisible, legal boundary surrounding a piece of land. It is important to note that no physical fences or barriers are required. Crossing this imaginary legal line without permission constitutes a breach. By establishing this clear rule, the court sought to maintain the king's peace, or contra pacem domini regis, and discourage individuals from resorting to violent self-help. Today, this tort is defined by two core legal characteristics that you need to be familiar with for your exams. First, trespass to land is actionable per se. This means the claimant does not need to prove that they suffered any actual damage or financial loss. The unauthorized entry itself is the legal injury. The definitive landmark authority for this principle is Entick v. Carrington. Second, it is a tort of strict liability for volition. This means legal liability depends entirely on whether the physical entry onto the land was voluntary. It does not matter whether the defendant intended to trespass or if they were even aware they were on someone else's property. Consequently, mistake is no defense. If a person accidentally crosses a boundary genuinely believing the land belongs to them, they remain legally liable. This was clearly demonstrated in the case of Baisley v. Clarkson. By contrast, involuntary entry is a valid defense. You will only be free from liability if you are forced onto the land entirely against your physical will, meaning you had no control over the physical act. The key authority for this exception is Smith v. Stone. Building on that historical context and the core characteristics we just covered, let's look closely at how modern law defines the meaning and purpose of this tort. Legally, trespass to land is defined as the unlawful, direct, and intentional interference with land that is in the lawful possession of another person. To understand why the law enforces this so strictly, we need to look at its four primary purposes. First, it is designed for the protection of pure possessory rights. As we established with the principle of actionable per se and the landmark case of Entick v. Carrington, this tort safeguards the absolute sanctity of exclusive possession. The law isn't looking to repair a physical loss, it is protecting the integrity of the right itself. Second, it ensures the maintenance of public order. Just like the 13th century courts aiming to uphold the king's peace or contra pacem domini regis, the modern tort acts as a legal pressure valve. By providing a clear legal remedy, it prevents dangerous personal self-help measures, such as forcible removals and violent escalations between parties. Third, it allows for the resolution of boundary disputes. Instead of neighbors escalating arguments over uncertain property lines, the tort provides a peaceful judicial mechanism. This allows parties to settle disagreements cleanly through remedies like court injunctions or declarations, rather than merely seeking financial damages. Finally, trespass to land serves a vital role in the protection of privacy. Because English common law historically lacks a standalone, comprehensive tort for the invasion of privacy, trespass effectively steps into that gap. It protects the home as a private sanctuary, providing individuals with a legal shield against unauthorized surveillance, media intrusion, or harassment. Now that we understand the core meaning and purpose behind the tort, let's move on to the specific elements you need to prove to establish a claim. Now that we fully understand the underlying meaning and purpose of this tort, we need to focus on how a claim is actually constructed in practice. To establish a prima facie case for trespass to land under UK law, the burden of proof lies with the claimant. Specifically, they must satisfy the court on 3 core elements. First, there must be direct interference. Second, that interference must stem from an intentional or voluntary act. And third, the claimant must hold exclusive possession of the land in question. These 3 requirements form the structural framework for any exam answer or problem question on this topic. If any one of these elements is missing, the claim will fail. In the upcoming slides, we will break down each of these 3 requirements one by one, looking closely at how the courts define them and the essential case law you need to apply. Let's begin by taking a detailed look at our first element, direct interference. As promised, let's focus on our very first requirement to establish a prima facie case, direct interference. The fundamental rule here is that the physical intrusion must be a direct, immediate, and uninterrupted consequence of the defendant's act. This marks a critical boundary in tort law. If the intrusion requires a time delay, a subsequent development, or an independent intervening force to complete the entry, the actionable wrong is actually private nuisance, not trespass. To understand this distinction clearly, the courts frequently rely on a classic judicial analogy from the historical case of Reynolds v. Clark. Imagine a person throws a log onto a highway and it strikes you as it falls. That injury is immediate and direct, which equates to trespass. On the other hand, if the log is thrown, lands safely on the road, and you subsequently trip over it in the dark, the injury is consequential and indirect. That falls under nuisance. We see this distinction applied strictly when we look at our key authorities. In Esso Petroleum v. Southport, oil was discharged from a ship into a river estuary and was subsequently carried to a shoreline by the ocean tide. The House of Lords held that because the oil was carried by an intervening force, the tide, the interference was consequential and indirect. Therefore, it failed the test for trespass. Conversely, consider the case of Gregory v. Piper. Here, the defendant piled rubbish against a wall, and as it dried, it inevitably rolled onto the neighbor's plot due to gravity. The court held this to be a direct interference. Because the natural laws of gravity made the entry an absolute certainty, there was no independent intervening force. Now that we have established what constitutes direct interference, let's move on to our second essential element, proving an intentional or voluntary act. With direct interference established, let's move on to our second core element, proving an intentional or voluntary act. The fundamental rule here is that to establish liability, the physical act of entry or interference must be entirely voluntary and intentional. However, there is a crucial legal nuance that you must highlight in your essays. The defendant does not need to intend to break the law, commit a wrong, or even realize they are crossing a boundary. Instead, the requirement for intent applies strictly to the physical movement that brought them onto the land. If they were in conscious control of their own muscles when they crossed the line, the element of intent is legally satisfied. To make this distinction clear for the examiner, you should rely on 2 contrasting key legal authorities. First, let's look at Baisley v. Clarkson. In this case, the defendant accidentally mowed a strip of his neighbor's grass, genuinely believing it was his own land. The court held that an honest mistake is no defense. Because he intended the physical movement of walking and mowing, his ignorance of the exact boundary line was legally irrelevant, and he was found liable. Now, contrast that with the case of Smith v. Stone. Here, the defendant was physically seized and thrown onto the claimant's land by a group of third parties. The court ruled that involuntary entry completely negates liability. Because he had zero physical control or volition over his movement, he was found not liable. Interestingly, the court noted that the third parties who actually threw him were the true trespassers. This underscores the strict nature of volition in this tort. Now that we understand direct interference and voluntary acts, let's examine our third and final element. This brings us to our third and final core element, possession of land. The fundamental rule here is one of the most frequently tested concepts in land law. Trespass to land is a tort against possession, not ownership. The proper claimant is not necessarily the person who holds the legal deeds, but rather the person who has actual physical control of the land, with the intention to exclude all others at the very moment the interference occurs. To master this element for your exams, you must understand the core distinction between actual physical possession and legal ownership, particularly in landlord-tenant relationships. Actual physical possession refers to day-to-day physical control. A classic example is a tenant living under a lease. Because the tenant holds exclusive possession, they can sue anyone for trespass, including their own landlord, if that landlord enters the property without prior authorization. Conversely, legal ownership often involves a reversionary interest. When a landlord rents out a property, they surrender immediate physical possession in exchange for rent. They merely retain the right to the property when the lease eventually expires. Therefore, a landlord cannot sue a temporary trespasser. They can only bring a legal claim if the trespass causes permanent structural damage that directly reduces the property's long-term value. Let's look at how the courts have applied this principle across 4 key authorities. First, in Jones v. Chappell, the court firmly established that only tenants can sue for simple trespass, while landlords must demonstrate permanent structural damage to have standing. Second, the case of Graham v. Pete provides a fascinating nuance. It shows that even squatters can sue random third-party intruders for trespass. Because the squatter has actual physical possession, which is a superior right against anyone who has zero legal rights to the land. Third, we must look at Delaney v. T.P. Smith, which clarifies that a person occupying land under a void lease fails against the true legal owner. While your possession might protect you against a random stranger, it cannot stop the rightful owner from legally evicting you. Finally, in Monsanto v. Tilley, the court held that having a fenced, secure, and tightly controlled site allows a company to sue intruders for trespass, proving that actual physical control is enough to bring a claim, even without a formal property deed. Now that we have fully broken down all 3 elements, direct interference, a voluntary act, and exclusive possession, we have everything we need to establish a prima facie case. Next, we will look at the various forms that a trespass to land can take. In our previous slides, we thoroughly broke down the 3 core elements required to establish a prima facie case: direct interference, a voluntary act, and exclusive possession. Now that we have that framework solid, let's explore the specific forms of trespass that can actually manifest in a legal scenario. It is a common misconception among students that trespass only occurs when someone physically takes an unauthorized step forward on the ground. But the law actually identifies several distinct forms of actionable interference. The first and most straightforward form is entering upon land. This involves physically stepping onto, driving across, or placing an object directly onto another person's land without their express or implied permission. The fundamental authority here is a case we've already introduced, the landmark decision of Entick v. Carrington. As we noted earlier, the court in this case famously articulated the strict protection given to real property, stating, "Our law holds the property of every man so sacred that no man can set his foot upon his neighbor's close without his leave." This case firmly cements the rule that any unauthorized physical entry constitutes an actionable tort, regardless of how minor it might seem. The second distinct form to look out for on this slide is remaining on land after permission is revoked. This scenario occurs when a person initially enters a property entirely lawfully under a license, meaning with the occupier's permission, but that license is subsequently withdrawn. Once permission is revoked, the individual is legally required to leave the land within a reasonable window of time. If they refuse to leave or deliberately linger, their legal status changes immediately, and they become a trespasser. A classic case authority for this principle is Wood v. Ledbetter. In this case, a man purchased a valid ticket to watch a horse race, but was subsequently asked to leave the premises by the occupier. The court established that once his contractual permission was revoked, his failure to leave the racecourse in a timely manner effectively turned him into a trespasser. Understanding these foundational varieties of physical presence on land is essential. From here, we can expand our understanding of how far the law's protection reaches, moving beyond the surface soil to look at how these rules apply to the airspace above and the subsoil below. In our previous slide, we looked at the first 2 ways an individual can commit a trespass on the surface soil, either by physically entering without permission or by refusing to leave once their license has been revoked. Now, let's expand our understanding of the various forms of trespass by looking at how the law handles more complex scenarios involving conditional rights, subsoil, and airspace. The third variety to consider here is abusing a right of entry. The legal rule dictates that if a person has a lawful right to use land for a specific limited purpose, such as traveling along a public highway or utilizing a designated right-of-way. But they choose to use that land for an entirely different, unauthorized purpose. They exceed their permission. Consequently, they legally become a trespasser from that moment forward. A classic example of this is the landmark case of Hickman v. Mazie. In this instance, a racing tout used a public highway solely for the purpose of watching and spying on racehorses that were being trained on adjacent private property. The court held that because highways are legally designated strictly for travel and passage, using them to spy exceeded his explicit right of entry, making him liable for trespass. This brings us to our final form of interference on this slide: trespass to airspace and the subsoil. Under English law, the legal definition of land extends well beyond the visible surface soil. Historically, this concept is rooted in the absolute Latin maxim, cujus est solum, ejus est, isque ad coelum et ad inferos, which translates to, whoever owns the soil, owns all the way up to heaven and down to the depths. While modern common law has placed practical, realistic limits on this, to a height and depth that is reasonably usable, the core principle still strongly protects property rights below the surface. To see this principle strictly applied to the subsoil, we look to the landmark Supreme Court decision in Bocardo SA v. Star Energy UK Onshore Limited. In this case, an energy company drilled diagonally from a neighboring property to extract oil lying between 800 and 2,800 feet directly beneath the claimant's estate. The Supreme Court firmly held that this unauthorized subterranean drilling constituted a trespass. The judgment confirmed that landowners hold proprietary rights to the strata underneath their properties down to a depth where human activity can usefully occur, regardless of whether the intrusion affects the day-to-day use of the surface soil. Now that we have analyzed how trespass can occur by abusing a right of entry or by penetrating the subsoil below, let's turn our attention upward and look at how the law handles unauthorized intrusions into a landowner's airspace. Having just seen in the Bocardo case how the law protects the subsoil deep beneath our feet, we now turn our attention in the opposite direction to the final form of interference: airspace. As we discussed with the Latin maxim ad coelum, a landowner's rights traditionally extend upward. However, modern law makes a very important distinction between lower airspace, the area immediately surrounding your buildings, and higher airspace where aircraft operate. First, let's look at lower airspace and the case of Kelson v. Imperial Tobacco Co. In this instance, an advertising sign fixed to a neighboring building protruded just 8 inches into the airspace above the claimant's single-story shop. Following the principle that trespass is actionable per se, the court granted an injunction. This case confirms that even a minor, harmless intrusion into lower airspace is a trespass, as it interferes with the area the landowner could potentially occupy. However, the law also recognizes a necessary high-altitude airspace exception. In the landmark case of Bernstein v. Skyviews and General Limited, the defendants flew an aircraft hundreds of feet above the claimant's country estate to take aerial photographs. Baron Bernstein sued for trespass, but the court held this was not an actionable wrong. The judge established a vital modern limit. A landowner's rights to the airspace above their property are restricted to the height necessary for the ordinary use and enjoyment of the land and the structures upon it. Once an intrusion occurs at a height beyond that, such as a commercial flight path or a high-altitude drone, the landowner no longer has a cause of action in trespass. Now that we have explored the various forms that trespass can take, from the surface soil to the subsoil and into the sky, we have a complete picture of how a prima facie case is built. In our next section, we will look at how a defendant can justify their actions by examining the defenses to trespass to land. Now that we have comprehensively explored all the different forms that trespass can take, from physical entries on the surface to intrusions deep into the subsoil and up into lower airspace, let's look at how a defendant can legally justify their actions. This introduces our next major exam topic: defenses in trespass. To escape legal liability entirely, a defendant must successfully rely on one of the recognized common law or statutory defenses. On this slide, we are focusing on the first and most common defense: consent, which is legally known as a license. The fundamental rule here is very clear. If the claimant gave the defendant permission to be on the land, no trespass has occurred. In your revision notes, you need to divide this defense into 2 distinct categories. First, we have an express license. This occurs when written or spoken permission is explicitly given to the defendant. Practical, everyday examples include inviting a friend over for dinner or purchasing a ticket to enter a cinema. Second, we have an implied license. This refers to customary, unwritten permission that is reasonably assumed through standard social behavior. For instance, a homeowner implies a license for postal carriers or members of the public to walk up their front path to knock on the door. The key case authority establishing this principle is Robson versus Hallett. However, for your exams, you must watch out for what is often called the trap, which is exceeding the license. If a defendant goes beyond the specific purpose, the permitted time frame, or the precise geographical area authorized by their license, the defense completely fails, and they instantly become a trespasser. To illustrate this to an examiner, you should always quote the famous judicial analogy from the Calgarth. In that case, Lord Justice Scruton memorably explained the limits of permission by stating, "When you invite a person into your house to use the stairs, you do not invite him to slide down the banisters." Now that we understand how consent functions as a defense, and how easily it can be exceeded, let's move on to the next slide to look at the remaining legal defenses available to a defendant. In our previous slide, we looked at how an occupier's own consent, or a license, can act as a complete defense, provided the visitor does not fall into the trap of exceeding that permission. Now, let's move on to our second major category of defenses in trespass: lawful authority. Unlike a license, which stems from the property owner, lawful authority is a statutory or common law power that grants certain individuals an absolute legal right to enter land without the occupier's permission. If an individual is acting strictly within the scope of these official powers, it serves as a total defense against a claim of trespass. On this slide, you need to be familiar with two primary examples of these powers for your exams. First, we have police powers. Under vital UK statutes like the Police and Criminal Evidence Act 1984, or PACE, police officers are granted explicit legal authority to enter and search private premises. This allows them to execute search warrants or arrest suspects without being held liable for crossing a property boundary. Second, the law grants similar powers to utility workers, employees of authorized statutory bodies, such as those managing electricity, water, or gas meters, frequently hold a legal right of entry to cross private property to inspect, maintain, or repair essential public infrastructure. However, just like exceeding a personal license, there is a massive examiner favorite on this slide that functions as another dangerous legal trap: the doctrine of trespass ab initio. The rule here dictates that if an official enters a property completely legally under the backing of lawful authority, but subsequently abuses that power by committing an unlawful act while on the premises, their legal protection is completely stripped away. The law applies a retroactive fiction, treating them as a trespasser from the very fraction of a second they first stepped onto the land. The leading historical authority you must cite for this principle is the Six Carpenters case. In that scenario, carpenters entered a public tavern lawfully, but then refused to pay for their wine. While the court in that specific instance drew a distinction between a nonfeasance and a misfeasance, the case firmly established the structural framework of trespass ab initio for any official who abuses their state-backed right of entry. Now that we have broken down both consent and lawful authority, let's move forward to the next slide to explore the remaining legal defenses available to a defendant. Moving on from our previous discussion on the defense of lawful authority, we now turn to the three distinct legal mechanisms a defendant can use to establish a claim of prescription. First, we have common law prescription. While the law technically requires continuous use dating all the way back to time immemorial, fixed at the year 1189, the courts will practically presume this if we can show 20 years of continuous use. However, its major flaw is that it is incredibly fragile. The claimant can defeat it simply by proving the use was impossible at some point after 1189, such as showing a building blocked the path in the 20th century. To bypass this vulnerability, the courts developed the second method, the doctrine of lost modern grant. This relies on a convenient legal fiction. If 20 years of continuous use as of right is proven, the court presumes a formal grant was legally executed in modern times but has simply been lost. The immense advantage here is that it completely immunizes the defense against arguments regarding what the land looked like back in 1189. Finally, we have the statutory route via the Prescription Act 1832. This introduces a strict next before action rule, meaning the timelines must be calculated directly backward from the date the trespass claim was issued. Under the 20-year threshold, the claim cannot be defeated by proving it started after 1189, though it will fail if oral or written permission was granted. At the 40-year mark, the right becomes absolute and indefeasible, meaning it is virtually unbeatable unless the claimant can produce a formal written agreement proving consent. Any significant interruption right before the action breaks this chain, completely undermining the defense. In our next slide, we will transition to looking at the defense of necessity. Now, let's explore our fourth major defense in trespass: necessity. A defendant can successfully claim necessity if they entered the claimant's land specifically to prevent a certain imminent danger. The law strictly divides this defense into two distinct categories: public necessity and private necessity. First, public necessity occurs when a person acts to protect the wider community. A classic example would be entering private land to extinguish a raging fire that threatens to burn down an entire village or town. Because this action is taken for the greater public good, it operates as a complete defense to trespass. On the other hand, we have private necessity. This applies when a defendant acts strictly to save themselves, their own property, or a small group of individuals. As established in the key case of Monsanto v. Tilly, this defense is tightly restricted by the courts. You cannot claim private necessity as a justification for social or political protest, such as pulling up genetically modified crops to make a point. The law requires the danger to be an actual, immediate emergency rather than a perceived social ill. In our next slide, we will transition to the next defense, the justification of right of entry by abatement and easement. Having just established the strict limits of necessity and how the courts refuse to allow it as a blanket justification for social protest, we arrive at our fourth and final category of defenses: justification by right of entry, which heavily features prescriptive rights, easements, and the common law right of abatement. The foundational rule for this slide is straightforward. If a defendant already holds a lawful pre-existing proprietary right over the land in question, they have a legal right to be there and cannot be successfully sued for trespass. On this slide, the syllabus breaks this defense down into two highly practical common law exceptions that you must be ready to analyze in problem scenarios. First, we have easements. This occurs when a person has a formally registered or legally acquired right-of-way across a piece of land owned by someone else. A classic example is a homeowner who must cross a neighbor's driveway to access their own garage. Because that right-of-way is legally recognized, utilizing that specific path is completely justified, and a claim in trespass will fail. Second, the law provides a fascinating self-help exception known as the abatement of nuisance. Under English law, a landowner has a strictly limited right to physically enter a neighbor's land without express permission, if their sole purpose is to put an immediate end to an active nuisance. For instance, if branches from your neighbor's tree are dangerously overhanging your garden, you have a legal right to cross the boundary line onto their land to chop them back. However, you must highlight a major exam pitfall here. This entry is only justified if you have provided reasonable notice to the neighbor first. Crossing over without giving notice, or going beyond what is strictly necessary to resolve the nuisance, will instantly strip away this defense and turn you into a trespasser. Now that we have comprehensively analyzed all four major defensive pillars, consent, lawful authority, necessity, and justification by right of entry, we have covered every single way a defendant can escape liability in an exam problem question. With liability and defenses completely mastered, we can move forward. Next, we will explore the specific remedies a claimant can seek from the courts before we transition into our broader evaluation of the law, specifically looking at how these principles contrast with property protections in criminal law, where we will evaluate the law of theft. Having just analyzed how a pre-existing proprietary interest or the common law right of abatement can completely justify an entry onto private land, we have officially covered all the ways a defendant can avoid liability in a problem scenario. But what happens if a defendant has no defense and a civil breach is fully established? This brings us to our current slide: remedies in trespass to land. When a claimant successfully proves an actionable trespass, the law provides a variety of judicial remedies. On this specific slide, we are focusing on the first major category: damages and injunctions. The first option for a claimant is to seek monetary compensation through damages. As you must emphasize to an examiner, because trespass to land is actionable per se, meaning it is actionable without proof of actual damage, the court will readily grant nominal damages. This is a small, symbolic financial award used to formally vindicate the claimant's right to exclusive possession when no physical harm has been done, tracking right back to the foundational principle in Entick v. Carrington. However, if the trespasser does leave a trail of destruction behind them, the court will shift to compensatory or substantial damages. This award is specifically calculated to cover physical harm to the land, structures, or fixtures. The court measures this either by the cost of reinstatement, meaning how much it costs to fix the property, or by the diminution, which is the overall reduction in the property's market value. The second major remedy listed on this slide is an injunction. In many land disputes, a one-off catch payment isn't enough. Landowners want the behavior stopped for good. Because property owners have an absolute right to exclude others, the courts frequently prefer granting an injunction over damages. This is a discretionary court order that strictly forbids a defendant from continuing or repeating their unauthorized interference with the claimant's exclusive possession. Now, while damages and injunctions are the most common starting points in a property dispute, we are not quite finished with our remedies framework just yet. Let's advance to the next slide to look at the remaining specialized remedies available to a claimant ahead of our final evaluation. In our previous slide, we established that while monetary damages can compensate a landowner, the court frequently prefers injunctions because they directly protect the right to exclusive possession. Building on that foundation, we now move into a more detailed examination of equitable remedies, specifically the two types of injunctions a court can grant at its discretion. The first is the prohibitory injunction. This is a court order that strictly restrains a defendant from entering or remaining on the claimant's land. While all equitable remedies are discretionary, the courts will routinely grant a prohibitory injunction for ongoing trespasses unless the result would be disproportionately oppressive to the defendant. A perfect authority to cite for your exams is Kelson v. Imperial Tobacco Co. You will recall that even though the defendant's advertising sign only protruded 8 inches into the claimant's airspace, the court granted an injunction for its removal, reinforcing the principle that the law will act to stop even a minor ongoing intrusion. The second type is the mandatory injunction. Unlike a prohibitory order, which stops an action from happening, a mandatory injunction requires the defendant to take positive active steps to rectify a trespass. This is most commonly utilized when a defendant has built an unauthorized structure, such as a wall or a shed, and encroaches across a boundary line. In these cases, the court can order the defendant to physically demolish or remove that structure to restore the claimant's land to its original state. While these court-ordered equitable remedies are incredibly powerful for resolving permanent disputes, they are not the only tools at a claimant's disposal. We still have several specialized remedies to explore, including the immediate self-help actions an occupier can take without waiting for a court. Let's move forward to look at those remaining remedies now. In our previous slide, we looked at judicial options like prohibitory and mandatory injunctions, which require a claimant to go through the formal court process to stop an ongoing interference. Now let's look at our final category of remedies on this current slide, self-help remedies. These are immediate actions an occupier can take directly, without waiting for a court order. The syllabus highlights 2 primary forms of self-help you must be ready to discuss in an exam problem question. The first is expulsion or ejection. The legal rule dictates that an occupier who is in exclusive possession of a property has the right to physically remove a trespasser. However, this right only arises if the trespasser has first been requested to leave and has been given a reasonable opportunity to do so voluntarily. If they refuse, you can use physical force to remove them, but as a major examiner favorite, that force must be strictly reasonable and proportionate. If an occupier uses excessive force, weaponizes the situation, or inflicts unnecessary injury, they lose their legal protection and can be sued by the trespasser for civil battery or even face criminal charges. The second form of self-help listed here is the abatement of nuisance. This remedy is historically rooted in property protection, allowing a neighbor to cross a boundary line to directly remove an active source of interference. As we highlighted when looking at defenses, A classic example is entering a neighbor's land to lop off tree branches that are dangerously overhanging your garden. Again, this self-help mechanism is tightly restricted and generally requires giving the neighbor reasonable notice before crossing the threshold. Now that we have comprehensively analyzed every element, form, defense, and remedy, we have built a complete, solid understanding of how the civil law functions. Next, we will pull all of these threads together to evaluate the entire law of trespass to land as a whole, assessing its strengths, its modern limitations, and how effectively it protects property rights before we transition into our study of criminal law. In our previous slide, we looked at self-help remedies like physical expulsion and the abatement of nuisance, which allow a landowner to take immediate non-judicial action to protect their property. Having now completed our operational journey through the elements, defenses, and remedies of the tort, we are ready to step back and critically analyze the tort as a whole. This brings us to our first core assessment topic. 1. Actionable per se. Protection versus triviality. The fact that trespass to land is actionable per se, meaning a claimant can sue without proving they suffered any physical or financial harm, is one of its most defining features. When evaluating this principle for an essay question, we must divide our analysis into two key camps: the justifications and the criticisms. Let's look first at the strengths. Under absolute sanctuary, by not requiring proof of damage, the law treats property rights as a sacred constitutional right. This echoes the seminal case of Entick v. Carrington, establishing that the state or individuals cannot step a foot onto your land without lawful authority. This strict approach prevents systemic incremental invasions of privacy before any permanent damage can even occur. Furthermore, it ensures deterrence and public order. If landowners were legally forced to wait for an intruder to cause physical damage before they could call upon the law, it would inevitably encourage dangerous self-help measures or violent confrontations to forcibly remove them. However, we must also highlight the flip side of this rule under the weaknesses. First, there is a clear risk of trivial litigation. Because no damage is needed to trigger a claim, it opens the floodgates to exceptionally petty or de minimis claims over technical boundary line crossings where zero social or economic harm has actually occurred. This links directly to an inflexible remedy system. Winning a completely nominal claim results in practically zero actual compensation for a claimant. Critics seize on this to argue that it wastes valuable, overburdened court time on minor neighborly spats that have no business being litigated. This tension between ironclad protection and trivial claims forms the vital foundation of your evaluation. Let's advance to our next slide to see how the law grapples with another highly controversial area: the stark balance between public and private rights. Building directly on that tension between absolute protection and trivial claims, we arrive at our next major evaluative theme: balancing public and private rights in trespass. When analyzing this for an essay question, you are evaluating a fundamental constitutional tug-of-war. The core conflict breaks down into two competing social demands. On one hand, we have private autonomy, which is the absolute right of landowners to exclude others and fully enjoy their own privacy. On the other hand, we have the collective interest, which represents the public's competing demands for assembly, peaceful protest, or necessary state intervention. The legal system manages this tension through two very different institutional approaches. First, consider common law, judicial protection, where the courts enforce strict control. The common law historically protects the landowner by restricting the legal landscape to exceptionally narrow defenses, such as a license, operation of law, or absolute necessity. Because trespass is actionable per se, the mere step across a boundary line triggers liability. Furthermore, protest is completely barred. The judiciary has consistently ruled that rights to peaceful protest or social activism never excuse invading private land. In the eyes of the common law, property rights explicitly trump freedom of expression. However, look at how the other branch of government responds under statute law, legislative rebalancing. Here we see a massive state expansion. Parliament routinely passes legislation that grants public bodies, such as the police, environmental inspectors, or utility workers, overriding statutory powers of entry. This dramatic contrast between judge-made restrictions and parliamentary expansions fuels an intense scholarly debate. legal academics actively evaluate whether these expanding state powers are absolutely vital for public welfare and a functioning modern society, or if they represent a dangerous, quiet erosion of traditional civil liberties. Now, while this public versus private boundary is a massive source of systemic friction, the law faces equally intense academic scrutiny when we look inward at the defendant's state of mind. Let's advance to our next evaluative slide to explore how the courts treat the controversial elements of intent and volition. As we move deeper into our critical analysis, we encounter a fundamental source of legal friction in this tort: the strict focus on physical volition over criminal or moral intent. This core conflict revolves around two primary concepts: the problem with ancient precedent and the underlying policy that defends it. Let's look first at the problem with Baisley v. Clarkson. The long-standing rule established by this case dictates that an honest mistake is no defense, which inevitably creates incredibly harsh outcomes in practice. For instance, an innocent, well-meaning walker who steps onto a poorly marked private field, genuinely believing it to be a public footpath, is still technically a tortfeasor in the eyes of the law. They had the physical volition to make the step, meaning their lack of bad intent is entirely irrelevant to establishing liability. However, there is a clear policy argument behind why the judiciary intentionally maintains this seemingly ruthless approach. The courts keep this high standard to prevent defendants from simply fabricating an ignorance defense whenever they cross onto someone else's land to avoid liability. Because property ownership records are publicly available, the law firmly places the heavy burden of checking and verifying boundaries entirely on the entrant. This ongoing tension between protecting landowners from easy excuses and unfairly penalizing completely innocent mistakes is a brilliant talking point for any high-scoring essay. Now, while we have just evaluated the internal mental boundaries of the tort, the law faces an equally complex challenge when defining its external physical limits. Let's advance to our next evaluative slide to explore how the courts handle the controversial rules surrounding dimensional boundaries, specifically how far private rights stretch up into the sky above and down into the ground below. Having just evaluated the internal mental boundaries of the tort, we now arrive at our next major analytical battleground: dimensional boundaries. When crafting an essay on this topic, you want to evaluate how effectively the old common law maxim that property rights stretch infinitely up to the heavens and down to the center of the earth has survived the demands of the modern world. The law splits this into distinct physical zones. First, consider the upper airspace and the landmark ruling in Lord Bernstein v. Skyviews. The verdict here is that the law is highly adaptable. By restricting a landowner's property rights to the height necessary for ordinary use and enjoyment, the courts successfully stopped homeowners from blocking commercial aviation, a pragmatism that was later codified by Parliament in the Civil Aviation Act 1982. Second, look at the lower airspace via Kelson v. Imperial Tobacco. The verdict here is far more critical. The framework is too rigid and under pressure. While this strict approach is excellent for stopping static structural intrusions like an overhanging advertising sign, it severely struggles to cope with modern consumer drones. This has created an ongoing regulatory gray area between personal privacy and low-altitude airspace. Third, we must look downward to the subsoil via the Supreme Court decision in Star Energy v. Bercardo. Critics label this verdict archaic and extreme. Holding a company liable for trespass for drilling oil pipelines thousands of feet below the surface shows a hyper-strict enforcement of property rights. Academics argue this outdated, rigid view risks stalling vital national infrastructure and resource extraction. This practical division introduces two massive critical flaws you can use to secure top marks in an essay. There is profound airspace subjectivity. The ordinary enjoyment test from Bernstein is an outdated, vague standard. It completely fails to protect landowners from modern drone surveillance because the law clumsily measures physical height instead of the actual privacy intrusion. This leaves us with a glaring subsoil paradox. The law is deeply inconsistent. It allows commercial airplanes to cross high above your property without any liability whatsoever. Yet it severely punishes infrastructure pipelines drilled deep below the surface, where no perceptible harm or disruption occurs. Now that we have comprehensively evaluated the tort's procedural triggers, public boundaries, mental state, and physical dimensions, let's advance to our final slide to bring all these threads together into our definitive conclusion. We have reached the end of our evaluation, bringing us to our final theme, the conclusion. This is where we tie our analytical threads together to deliver a powerful, high-grade essay ending. Ultimately, the modern tort of trespass to land is caught in a structural tug-of-war between historical rights protection and 21st century reality. While modern torts like negligence focus heavily on loss allocation and proof of damage, trespass remains fiercely anchored to its original constitutional purpose, protecting the absolute sanctity of property boundaries. When summarizing this for an examiner, you want to split your conclusion into two distinct areas. First, look at the current verdict. Where does it succeed, and where does it fail? Oh, the success. Its strict liability nature and status as actionable per se provide an incredibly clean, certain, and effective tool for maintaining public order, resolving boundary disputes, and preventing dangerous, self-help confrontations. Oh, the failure. Conversely, its rigid, spatial rules have created a blaring legal asymmetry. The common law successfully adapted upper airspace for commercial aviation in Lord Bernstein, yet it remains absurdly restrictive deep underground following Bocardo, and dangerously ambiguous regarding modern consumer drone surveillance. This brings us to the final synoptic thought. Trespass to land remains a powerful shield for property owners. However, to remain a relevant instrument of justice, it must move past century-old physical boundaries and adapt to an era where technology routinely challenges the traditional definition of a boundary line. Equipping your students with this balanced, forward-looking perspective will ensure they can conclude any essay on trespass with maximum impact. Thank you all so much for your time. I will see you in the next lecture.